Daily. I'm the managing principal of Multnomah Group. Today's presentation is really a back to basics exploration of fiduciary responsibility under the Employee Retirement Income Security Act. Before we get too deep into the presentation, I thought I'd do just a little bit of housekeeping. First of which is we're recording today's presentation, so to the extent you feel like you may have missed something or want to go back and review it, you'll have an opportunity to do so. We'll also be sending out a copy of the materials as well. So if that's something you'd like to memorialize along with the presentation, feel free to do so. And consistent with the responsibilities of fiduciaries, if you happen to be one, probably keeping this date and recording as part of your ongoing training process would be a wise step in documenting your prudence as a fiduciary to the plan. The next piece, you've all been muted to try and keep the call quality high from a recording perspective. However, to the extent you have questions, you'll notice in the Zoom app there's a Q&A section. I'm happy to take questions. I prefer it. So as you have those questions, please feel free to enter them and I'll either capture them over the course of today's presentation or at the conclusion. You know, one of the things I'm most proud of as far as accomplishments in 2018 for the team here at Multnomah Group is really the development of a comprehensive fiduciary training curriculum for clients. We have put together almost a coursework type structure that has dozens of presentations oriented towards trying to help educate retirement plan committees on their responsibilities in operating, monitoring their qualified retirement benefit plans. Today's presentation is really the foundational block of that, the Level 100 training program related to fiduciary obligations under the Employee Retirement Income Security Act. And as we get into today's presentation, we're hoping you leave really with three things as takeaways. Certainly an understanding of what the rules and regulations are related to retirement plans under the Employee Retirement Income Security Act, what it means to be a retirement plan fiduciary and the associated responsibilities with carrying that title. And last, while we're not encouraging you to do it, it's probably important to know what the consequences are for violating the Employee Retirement Income Security Act. So with that, I'll go ahead and get started. When we look at the rules and regulations governing qualified retirement plans, especially among private non-governmental employers, they fall into two categories. Certainly the one we'll spend the most time on because it's where the fiduciary obligations lie is in the Employee Retirement Income Security Act. For sake of ease and because it's probably how you'll hear it from this point forward, I'll refer to it as ERISA. And it is the full comprehensive body of law that governs retirement plans. The Employee Retirement Income Security Act then is enforced by the Department of Labor. And the Department of Labor has within it the Employee Benefit Security Agency, which goes about the process of auditing, reviewing, and ensuring that the fiduciary obligations of plan sponsors are being met. And as a result, the plan participants that these plans cover are protected. Secondary to that, although certainly just as critical from a plan operation perspective, is the Internal Revenue Code, or the IRC. These employee benefit plans carry significant tax benefits, both to employees and employers. And as a result, for conveying these tax benefits, the Internal Revenue Service has very strict guidelines about how plans must be operated and the rules of engagement. So the Internal Revenue Code and the IRS assists in ensuring that those plan provisions and the tax qualification obligations of retirement plans are ultimately met. So if you get into the Employee Retirement Income Security Act, and I'm certainly not suggesting that that would be a good use of your time, there's hundreds and hundreds of pages and cross-reference documents as part of the Employee Retirement Income Security Act. However, if you want to look smart in a committee meeting or with your friends, depending on the types of friends you may associate with, I would argue there's three sections of the Employee Retirement Income Security Act that you should be familiar with. Not soup to nuts, but understanding what's contained in those sections because ultimately it'll drive the overwhelming majority of how you operate as a plan fiduciary. The first is Section 404, and Section 404 says relatively simply and concisely what you have to do as a retirement plan fiduciary. And while there is case law and briefs and opinions and best practices, ultimately 404 comes down to 4 critical obligations. A duty of loyalty, so when you're acting in a fiduciary capacity, being loyal to the participants and beneficiaries of the plan. A duty of prudence, and that's a relatively high burden, and we'll talk about it. The prudence to select and run the plan in a way that's consistent, again, with the needs of the participant population. A duty to diversify investments, and a duty to follow the plan document. Those are relatively straightforward obligations. As we get into the operational components of those, that's when it becomes far more complicated. Then we move over to Section 406. If 404 is what you can do, Section 406 is what you cannot do. So these are what are called prohibited transactions. So the plan can't engage in transactions with parties in interest because there would be a potential conflict that would adversely affect the participants. And as a result, plans can't engage with fiduciaries in transactions. I can't be on a committee and then also sell investment products for a commission to the committees that I am a member of. That would be a prohibited transaction. And then Section 408 carves out some very limited exceptions to what can and cannot be done under Section 406. So the list of statutory exemptions with service providers and how ultimately they tie into the compensation received is critically important in Section 408. For those that work with plans and certainly on the participant side, you may be familiar with Section 408B2, which requires service providers to say what services they're providing, whether they serve in a fiduciary capacity, and any compensation that they may receive. Their obligation to do that, again, comes out of this Section 408. The next piece then is deciding ultimately A, who are the fiduciaries to any given retirement plan, and then B, what are their obligations? So let's start with who are the fiduciaries to a retirement plan. Ultimately, fiduciaries generally are driven by ERISA Section 321, which defines what a fiduciary is. And if you look at Section 321, it's any individual who exercises discretion over the management of a plan or its assets, any individual who renders investment advice to the plan or a participant in the plan for compensation, and any individual who has discretionary authority in the administration of the plan. Discretionary being the critical word here. If I'm merely doing things that are operationally required where I don't have individual discretion, that may not cause me to be a fiduciary to the retirement. So if we look at 321, 321 is where we define fiduciaries based on their actions. What do they do relative to the operation of the plan? It's also important to point out that each retirement plan must have a plan document. And within every plan document, there should be a state that says ultimately who at least one fiduciary to the retirement plan may be. So we may have one set of fiduciaries that is driven by ultimately their responsibilities or activities relative to the plan, and at the same time have a fiduciary that's named in the plan document. Frequently, depending on how the document's drafted and whether it was drafted by counsel or by a provider, you'll have a plan document that either points back to the plan sponsor, the employer, as being the fiduciary, or states that a committee as delegated by the board and the name of the committee serves in a fiduciary capacity. So 2 places where ultimately you could end up having fiduciary responsibilities. 1, based on your job activities, what are your responsibilities? And 2, if you're ultimately named or part of a group named in the plan document, that would have an impact on your status as fiduciaries. Once we define that organization, it is also important to understand that those fiduciaries may delegate some aspects of plan administration either to internal parties, other employees of the organization, or external parties, third-party service providers, to render certain services to the plan, to its participants, and others. However, there is no escaping the fiduciary responsibilities that I'm going to talk about today. Any delegated fiduciary activity has to be monitored So the selection of who you're delegating to and the monitoring of the quality and cost relative to that delegation is critically important. So if anybody comes and says, I can take away your fiduciary responsibility, it's inaccurate. It may change the nature of your fiduciary responsibility from one of action to one of review, but it doesn't fundamentally remove that obligation for a planned fiduciary as defined either under Section 321 or as driven out of the plan document. It is also important to point out that not all activities relative to a retirement plan are fiduciary in nature. If we think at it at a very simplistic perspective, there are some issues that are fiduciary and that have all the obligations and responsibilities that we'll talk about today. There are another set that are called settlor decisions, and these are decisions that are relative to the business's decision to operate, define eligibility from a plan. So let's start on the right-hand side. What would be considered fiduciary decisions relative plan operation? So certainly things like what investment options do we want to make available in the defined contribution plan? Those would be fiduciary in nature, driven by a 321 fiduciary or a named plan fiduciary in the plan. Which service providers do we hire and how much do we pay those service providers for the services that they render? Again, fiduciary decisions defined by the obligations of the Employee Retirement Income Security Act. Where committees frequently fall into confusion are other issues that are equally impactful, in some cases perhaps even more impactful, but ultimately are not obligated to that same fiduciary responsibility. So clearly an employer's decision to start a plan is not fiduciary in nature. They can say, I want to have a benefit, I want the benefit to be this large. Their decision to say, I can't afford the benefit anymore, terminating the benefit, again, a settlor decision that would be defined by an organization. However, the big area of confusion for committees falls in the area of plan design. So ultimately the settlor, in this case the employer, the organization sponsoring the plan, always defines things like who's eligible for the plan, how much benefit do we, the employer, want to provide, is there a vesting schedule on that benefit? Those are all critical foundational pieces of how a plan operates. Other plan design issues that are settlor in nature. Does a plan offer loans? That's a decision of the employer. While a fiduciary may have an opinion on whether it's useful for driving participation or it impacts leakage, the decision isn't fiduciary in nature. The same would be true of, do we have automatic enrollment? Automatic enrollment would be a settlor decision. Does the employer wish to make that part of the plan? Again, the fiduciary committee may have an opinion, may make a recommendation to add automatic enrollment, but the decision ultimately to modify the plan would be that of the organization. Same thing with hardships and other critical issues that committees spend lots of time on. That's not to say that committees should stop spending time on these issues, but as you document the process, it is important to point out when the fiduciary committee may be making a recommendation to the settlor to make an adjustment to the plan, relative when the fiduciary committee is making decisions independently to remove investment product A and instead replace it with investment product B. How we document that is a good signaling to the Department of Labor, to litigators and others, that the committee has a firm understanding of what their responsibilities are under the Employee Retirement Income Security Act as planned fiduciaries. So now let's move into the responsibilities of being a fiduciary under the Employee Retirement Income Security Act. I talked a little bit about them in Section 404, and again, they're relatively straightforward. Again, this acting solely in the interest of plan participants and beneficiaries. So almost every plan fiduciary that I've ever interacted with has other aspects of their job responsibility. When we walk into that committee room and begin talking about what our obligations are and the decisions we want to make, all of those decisions should be made exclusively with those parties, again, participants and beneficiaries. The most difficult piece, I think, for committees to try and demonstrate as they go about their work is this carrying out their duties prudently. If we look at the obligations of being a fiduciary under the Employee Retirement Income Security Act, they're very, very high. How do we document the prudence that we've accepted those responsibilities and carried them out in responsibility? The one that ultimately I think fiduciaries can spend more time on, and ultimately should, is the notion of following plan documents. The Employee Retirement Income Security Act is one of the few areas where they say, hey, you, employer, can put together a rule book, your plan document. All we ask is that A, the rule book comply with law, and B, that you apply the rule book consistently. In the areas of inconsistent operation where the plan document may say we do A, which is perfectly permissible, but in fact operationally we're doing B, are frequent. So having a process by which you go through the review of that and try and remove those gaps, I think is critically important. The notion of diversifying plan investments is usually a pretty quick checkbox for most employers. Again, most defined contribution plans have moved to a participant directed investment allocation scheme, meaning that participants can select one or many investments and create their own allocation. So satisfying the requirement to diversify is relatively simple at a plan level. And the one that's been talked about dramatically and tremendously really over the course of the last decade is this notion of paying only reasonable plan expenses. Obviously, especially in a defined contribution setting, how much I'll have as a participant in my plan will be dictated in some part by A, how much I put in, B, how much my employer put in, C, how I chose to invest those assets, but D, any expenses that I may have incurred in meeting that strategy. And since as a participant I have no ability to change, modify, renegotiate that cost structure, it's done by the fiduciaries, that responsibility is a critical one. If we look at the class action litigation, you'll note that that's an area of intense focus. It's one where the greatest opportunity exists for class action litigants to try and accrue settlements with plan sponsors and fiduciaries. Of all those responsibilities, though, the one that is most important, as defined by the Department of Labor, is this notion of prudence. How do we demonstrate that prudent process? Because it impacts all these other aspects, whether we're diversified, whether our expenses are reasonable, whether we're following our plan document, whether we're acting solely in the interest of plan participants. The only way to evidence that is by accurately documenting the process and effort that you've gone through as a committee to meet your responsibilities. So let's talk a little bit about the prudent process. I mean, as we look at our entire fiduciary training curriculum, it's really driven off this notion that everything we do from a retirement plan operations perspective falls into this process wheel. And typically it starts with gathering relevant information. And that gathering relevant information really applies to all aspects of the retirement plan. Certainly as committees set priorities, which is happening now as we look at the 2019 calendar year, what do we want to try and get accomplished? But we have to gather relevant information to know what the issues are. Putting together agendas, how are we going to go through the process of defining the information that we need to receive so that we can ultimately make decisions, and even drafting minutes. Do we have the relevant information to demonstrate our process? And then committees go through the process of then taking all this information and trying to analyze it, make sense of what is a broad variety of data. I think it's interesting over the course of the last decade how much more information we can get about how participants interact with the plan and how that may impact their decision making, good or bad, relative to participant-directed defined contribution. Meeting and making decisions, I think for committees, there is typically two areas or at least two ends of the continuum spectrum that are challenging. You have some committees that because of the workload relative to committee members, getting them to meet is difficult, and as a result, getting them to make decisions. On the other hand, you have highly deliberative committees who are fearful of making decisions. Neither of those tends to work well. You really want to have a good committee dedicated with adequate time to analyze things in a relatively short period of time and make informed decisions. Collect additional information, analyze additional information as necessary. But ultimately, making decisions or taking discretion is a big piece of the fiduciary responsibility that committees have. And then last, and certainly not least, arguably most important of all, is documenting the process. I think if we talk about how we're ultimately going to be judged, it's going to be on that documentation piece. Because ultimately, as we go through the process of making decisions, relative plans, the documentation element of this is how we will be judged in our fiduciary capacity. So I want to transition a little bit to the service provider side. I think at this point, you'd be hard-pressed to find a retirement plan sponsor that doesn't delegate all or many of the operational responsibilities relative to maintaining a retirement benefit program for their participants. And as we look at that, it really falls into 5 critical areas where we see delegation. So on the record-keeping side, you're traditionally finding some organization that can provide the technology that would allow participants access to information, to track their account, manage the tax elements, the reporting elements of what a participant may accumulate. On the communication education side, we tend to be outsourcing to ultimately individuals and providers who can provide actionable information to participants, but do it within the construct of what the legal requirements are, both from a disclosure perspective, but also not running afoul of the participant communication obligations that we have as plan sponsors. A number of organizations retain external legal counsel to assist in ensuring that the committee is protected and aware of the relevant legal issues impacting qualified retirement plans. And again, the way that that impacts both the employer, the committee, the plan, and the participants. For most employers of a certain size, there's a need to have an external audit, an organization that comes through, evaluates the operation of the plan, looks for control issues, both with your external service providers as well as with your committee and payroll process, to again help ensure that participants are protected when they have money deferred or contributed to a plan on their behalf. And then there's the investment analysis piece. The vast majority of organizations, even those with very sophisticated treasury departments, don't have the time or expertise in this particular area of investment analysis. If I'm a college or university with a $200 million endowment, the types of investment strategies I would be incorporating there wouldn't be relative or appropriate for a qualified retirement. But the important element of this, again, goes back to the notion that once you've made a hiring decision, merely hiring and then forgetting does not satisfy your obligations of prudence under the Employee Retirement Income Security Act. So your obligation to continually and regularly monitor the performance of those providers, all of them becomes important to satisfying your obligations. When we look at the service provider structure, it is relatively straightforward. And this is not true of every single retirement plan in the country, but it is the most prevalent model of delegation, where we have a delegation made from the plan sponsor, the employer, to a committee, the retirement committee of your choosing. And then the retirement committee really should be in the business of selecting and monitoring those providers that I talked about earlier, the attorney that's providing counsel to the committee, the auditors who are protecting the participants by reviewing plan financial statements and controls, the investment consultant who should be making fiduciary recommendations to the committee about investment product usage and inclusion, and the third-party record keeper and administrator, who is, for at least participants, the primary point of contact, their primary point of contact with the retirement benefit program. So on the fiduciary structure side, I think it's important to really talk about how those committees typically are established. As part of our ongoing fiduciary training, we have best practices and other things about how ultimately organizations should establish and select committee members. That being said, I think when we look at the responsibilities of a committee and governance, we think there are 2 pieces of the puzzle that committees should be aware of and should at least have an idea as to how to put together and ultimately monitor. One of those is a committee charter. So when we get a fiduciary delegation from a board, from an employer to a committee, typically that committee charter is the board or the employer establishing the membership and the rules of the committee. So maybe the committee has 5 members, maybe 3 of them are from finance and 2 are from HR. Maybe it's got 7 and it's got folks that don't operate within the administration sides of the organization. But who are the members, who selects, how long do they serve, and what are their obligations? By maintaining that document, it really helps the board demonstrate their delegation. The same way a committee needs to monitor the delegation they may make to a service provider, a board has an obligation to monitor their delegation to a committee. The charter really establishes the rules and expectations that the board has of the committee in their day-to-day operation. And the second is an investment policy statement. Organizations have changed. That's typical. As a result, committees have changed. Having a long-term investment thesis and strategy that doesn't change with the whims of membership changes allows more consistency, and ultimately that consistency typically helps participants achieve better outcomes over long periods of time. So we've managed to make it 13 pages into the deck, and I haven't talked about where committees tend to spend the majority of their time, and that's on the investment piece. Clearly, information on the investment side changes with some regularity, and ultimately it's where committees frequently feel the most anxiety. It's where they're less familiar, and they do tend to have to rely more on external parties to make recommendations and help them achieve good outcomes for their participants. So when we look at the investment piece, I'm not going to get into the specifics of how you would put the best investment menu together for your population. What I would point out is that the investment structure piece really has a number of different fundamental pieces. Certainly the one that committees spend lots of time on is just reviewing investment products. Do I like investment product A? Do I like investment product B? Should I make both of them, one of them, or none of them available in my retirement plan? I would argue that equally important to a good committee is also putting together a fundamental framework as to how those investment options are communicated and packaged to participants. And when we talk about the number and type of investment tiers, that process ultimately is designed to try and help a participant who has an even lower level of sophistication typically than the committee identify types of investment products and structures that may be appropriate for them as participants. Once we've defined those asset classes, those tiers, then we go through the next stage of putting investment products into those buckets, right? And as we get into the selection of investment option process, what's changed dramatically over the course of the last decade is the notion of default investment options. With the prevalence of automatic enrollment for plans that don't require participation to accrue benefits, an increasingly large number of participants are not electing to manage their own portfolios, but instead are being defaulted into an investment strategy. And while committees receive some level of protection for participants who don't make elections, the responsibility to select appropriate default investment structures is arguably the highest of the types of investment products that we make available to participants. So how do we go through the process of selecting default investment options and monitoring their appropriateness, augmenting that in most cases with a core investment menu where participants can put together their own allocation, and in some cases, reviewing the managed account providers. If you're a plan that's elected to have given participants the ability to have an external party put together their investment allocation, that incurs a cost, and is, as a result, the performance and success relative to the cost of that managed account is something that the fiduciaries need to be concerned with. Clearly, because investments change frequently, and when I say they change frequently, I don't mean, well, in the third quarter, equity markets were good, and in the fourth quarter, equity markets were not good. I mean things like investment managers change, cost structures change, strategies change, investment products merge away. The necessity to monitor investments on a regular and consistent basis is important. Periodically, we'll have organizations come and say, hey, would you take a look at our investment menu at a point in time? The challenge, of course, with that is that no sooner that I walk out the door, there can be a change to investment strategy that wouldn't be captured by those types of point-in-time monitoring approaches. Having a regular ongoing monitoring process, I think, is critical to meeting the prudence obligations under the Employee Retirement Income Security. And the last piece is, because of that ongoing responsibility to monitor, it will be necessary to replace investment options. I think from a participant perspective, from an operational perspective, from a disclosure perspective, having a high level of investment change frequency is certainly not desirable. But from a prudence perspective, avoiding making necessary or appropriate or prudent investment changes because it's disruptive, I think, is equally imprudent. So making sure that we're identifying real opportunities to help protect participants and avoid risk, incurring, monitoring, and associating the plan with high-quality investment managers, and obviously objectively looking at their performance relative benchmarks is a big piece of this investment prudence process. The hard part is, given the sophistication of information that tends to come through this investment piece, how do you as a committee then go through the process of documenting the prudence aspect of not only investment monitoring, but all of the responsibilities of plan fiduciaries under the Employee Retirement Income Security? So as we get into documentation, that is the area where ultimately we'll be able to either demonstrate that we were prudent, or we will be questioned based on our lack of documentation. And when we talk about documentation, I think it's important to point out that documentation has a pretty broad intended audience. So clearly, documentation is tremendously useful to the committee to help them remember what we did 3 months ago, where we are in our project plan, what our obligations are, where do we have open items, how are we prepared to make decisions. That documentation is relatively straightforward. For those of you that have your plans audited, I think almost every independent auditor in the country is asking for your minutes as part of their audit process. So it helps auditors understand, what is the committee doing, where are their challenges, what should we be aware of as we test the retirement plan for internal controls, fraud, and prepare the annual financial statement. Regulators. So for those of you that have had the great privilege of spending time with either the Department of Labor or Internal Revenue Service as part of their normal audit process, clearly they'll be looking at minutes. And as we get back to the notion of understanding the differences between fiduciary and settler functions, that's an area where they'll spend time to ensure that the committee has an understanding of what their obligations are and are carrying those obligations out. And last but not least is litigators. So if we look at the most recent spate of class action suits, when we get into the discovery process, certainly meeting minutes and documentation, investment reports, other things are all discoverable documents. And as a result, when we're putting together documentation, the documentation that's assembled needs to be appropriate for all four of those intended audience. And it needs to not only be a useful history or contemporary approach to what we're working on, but importantly, as we talk about litigators and regulators, it'll be important that it is at least detailed enough that it would allow you as a plan fiduciary who may be part of a deposition process to look over those notes and hopefully get yourself back to a point that was roughly similar to where you were when you made those decisions. So when regulators or litigators are testing prudence, documentation is going to be a big piece of that. And as you get into the deposition chair, you want to be able to try and get back to the frame of mind, recall the documentation you looked at, the discussions you had, so that you'll be in a better position to reflect on the prudence of the decision that was made. Because, and this is actually, thankfully, as we look at some of the class action litigation that's made its way into the hands of judges at this point, there is an acknowledgement among knowledgeable courts that our obligations as planned fiduciaries are not that the outcome of our decision is always right and always accurate. However, it is a test of prudence. So when we look at some of the class action litigation, courts have pointed out quite accurately and responsibly, I believe, that the notion that an investment may have underperformed in any given period of time isn't the test. The test is, did the committee at the time make an informed and prudent decision? And that's how we'll be judged. And as a result, the documentation piece is critical. In the end, whether the fund was up or down, we can obviously tell in retrospect, but how we got to the decision will be how we should be judged in the court of law. And then we always add this for last because, I think there's a fundamental understanding that fiduciaries have an obligation. Many of the folks on this call are likely fiduciaries to their own qualified retirement plans. And I do think it's appropriate for committee members to have an understanding of what their both obligations are, but also what the consequences for failing to meet those obligations are. I said there's those three sections, 404, 406, 408. We'll add one more at the end, which is 409, which talks about what happens when there are breaches of fiduciary duty. And what is relatively unique about the Employee Retirement Income Security Act is that responsibilities of fiduciaries fall on individuals. So you may be a member of a committee. That committee may be chartered. It may be delegated by your board. That committee doesn't protect you as a member of the committee for a fiduciary breach that you may enact. Obviously, the benefit of this structure from a protections perspective is no individual can shirk their responsibilities or pass the buck to an institution or a committee. The responsibilities look through that organization to the individual members or fiduciaries. As a result, ultimately, it's important to understand what those obligations and potential consequences may be. So typically, most of the Employee Retirement Income Security Act breaches would fall into the restoring losses. If you had a fiduciary breach, you caused your plan to pay too much for service A or investment B, there would be a calculation of that cost, and the responsibility would be of the fiduciaries to make participants whole. In some cases, for these prohibited transactions, there may be monetary penalties or taxes associated with the plan or plan fiduciaries for their breaches of fiduciary duty. And in rare cases, criminal prosecution, right? So if I paid too much for a service provider, that does not mean I'm very likely to arrive at criminal prosecution. Criminal prosecution would much more likely be not only was I a bad fiduciary, but I was such a bad fiduciary that I stole money from the plan. But clearly that is one of the obligations. And cases for breaches can be brought by the Department of Labor. So they come in for an audit and feel like a breach has been significant enough. Certainly their remedies fall under the monetary side, but could go to criminal prosecution. The same can be true of plaintiffs. So if you look at these class action cases, what they are ultimately is a participant, or frequently obviously a large group of participants, claiming a fiduciary breach and using counsel and the courts to try and get a remedy for that perceived breach. That doesn't mean that all of you should hang up on today's call and wander in to whoever the chair of the committee is and resign your committee membership. But I do think that it's important for committee members to both A, understand what indemnification may be provided by the employer. So if you're acting in good faith, serving as a good committee member, it's entirely appropriate for the employer to indemnify committees for their good faith actions. And B, I think it's important to understand whatever associated insurance coverage the committee or organization may have for fiduciary breach cases. because that'll be a critical piece of the pie, is in the unlikely event. These are unlikely. They're happening more frequently, but given the number of retirement plans in the country, they're still relatively infrequent. If we look at these class action litigation cases, making sure that there is adequate protection, legal costs built into your insurance structure to accommodate cases that can go on for years and years and years. Plan errors. I think it's also important to point out, no matter how good a fiduciary you are, no matter how good your payroll department is, no matter how good your finance and human resource departments are, plan errors will occur. If you have a plan of any size, on an annual basis, probably you'll have some form of small error, breach, problem related to plan operation. Some of them may be caused on the payroll side, some of them may be on the record keeper side or the parties that you've outsourced services to, but they happen. And I think that there is an understanding from the IRS and the Department of Labor that they do happen. I think ultimately the obligation of good fiduciaries is to try and have processes in place to ensure that those errors are caught quickly. So whether it's caught in the payroll as part of their internal audit of their payroll files, whether it's a periodic review of plan operation that committees engage in on a semi-regular basis. For most plans, again, there's this independent external audit where those types of plan operations can be caught. And then ultimately what you want to try and avoid is by using those first three approaches, having the Internal Revenue Service and Department of Labor find your errors for you. The beauty is in the top three options. If you find your own error, the IRS and the Department of Labor have voluntary correction programs that encourage you as a plan sponsor or fiduciary to correct small errors and to do so in a way that's relatively inexpensive. Then, when the IRS or Department of Labor come, if you failed to make those corrections, you no longer have the ability to go through that self-correction process. At that point, you're awaiting a decision from the department or the Internal Revenue Service about how they would like you to correct and what any associated financial penalties that may come through that process. So if we look at fiduciary breaches and obligations, that prudence of process flows through the entire piece. If I'm a class action litigator, I'm focused on your fees and your investment performance. If I'm a regulator, I'm probably focused on your plan operation. Are you following the terms of your plan document? Are you meeting your disclosure obligations to participants? But having this ongoing review process, defining when those breaches will occur and then repairing them prior to having any negative experience with the Department of Labor or the Internal Revenue Services. So as we close out, I hope that gives you a good foundational understanding. Those are obviously highly complicated topics. And as we make our way through the year, we'll have an opportunity to invite many of you to attend our 200-level series topics on fiduciary training and our 300, where we get into much more of the day-to-day specifics related to the topics we discussed today. But it's good to have the building blocks, which are this foundational understanding of your obligations, both under the Internal Revenue Code in exchange for the tax preference that these plans receive, as well as the Employee Retirement Income Security Act and your obligations to participants that flow through that particular act. This notion of having a process and documenting that process is critical. Documentation is, in the event of an audit from a regulator or, again, from a litigator, is what will ultimately protect you. And then last but not least is an understanding that even with the best of processes, errors will occur, but discovering the error, having methods to discover the error, and understanding how to correct them creates a great deal of flexibility and ultimately protection for plan sponsors and fiduciaries. So with that, I'm going to, A, thank you for your time today. B, open it up for questions. I think we've got a few minutes left before the close of the hour. So again, I'll remind you that you've got the Q&A box there with the Zoom application. I'll give you a few minutes to ultimately tap out some questions if you have them. That said, it frequently happens that a question pops to mind just after we close the call. Feel free to reach out to me directly. I'm always happy to try and answer as many of those questions as I can, because we really do appreciate your time and interest in the topic today. Give it one more minute for the slow typers. Well, with that, I think I'm going to close the call today again with one last thank you for your participation today. We do appreciate it, and again, hope to see you at a future 200 level course on some of these same topics. Thanks, and have a great day.